as the court dismissed the AG who is representing the state now because no law firm cannot represent the state, I kind of understand the question, but I don't know if you understand it. You know,
I'm not so sure if I understand that. What he's
yeah,
probably saying is that what
with
he's
respect
saying
to
is
the
that
AG, you know, yeah, go
Reggie
ahead.
Armour, go
Yeah.
ahead.
No,
You go
you go
ahead.
ahead. Go ahead,
No, I was just about to say that Reginald Armour, who is a friend of mine, um, um, personally, not see him all the time, but I consider him a friend of mine. I have a lot of respect for him. He's extraordinarily likable. When we were at Kville, I don't know if he was president of the student body, but even if he weren't, he certainly was one of the people that everybody liked. And he never changed. That demeanor in him never changed. He's also a very brilliant person. So he's not one of those persons that didn't earn their senior counsel designation. And to be called a senior counsel, there's no way he cannot remember the time, because that is the highest accolade that the profession can present to a member, to a lawyer, to be called senior counsel. And in fact, when you are in chambers with senior counsel, you don't call him Reggie or Mr. Armour, you say senior, because senior is that respect. So coming to the issue with Mr. Armour, it's a very unfortunate set of circumstances, but the fact of the matter is that he did work and did act for Brian Quaitong in his criminal matters in Trinidad, which are related to the exact same matters that are before the Miami court, except it's in its civil jurisdiction. But many of the facts, much of the evidence that would have been used in the criminal matter would obviously find its way in a civil jurisdiction, with the state trying to recoup some of its money, which it said that was misappropriated through bribery and corruption allegedly by Mr. Quaitong and Ishkal Baransing and Steve Ferguson. So the issue became that he had, and this is where he made the biggest mistake, this basic reason for his not having acted at all from the very beginning, the matter came over his desk from the very beginning, is because of that question of confidentiality. It is an absolute privilege. Your retainer with a client can come to an end, but the duty of confidentiality remains with you until death do you part. And that's for good reason, because when a client comes to you, he is going to tell you things that even his wife or children, those close to him, may not know. But he has to tell you if you're going to represent him well in court, because he certainly does not want to find himself in a situation where the other side has information and then suddenly they ask the question in cross-examination and you are caught on your legs, not knowing how to respond, and then you ask your client, but why you didn't tell me that? Well, I didn't know they were going to find that out. No, no, no. So there must be that absolute duty of confidentiality. It is an unqualified duty, so that when Mr. Armour acted as counsel for Brian Quaitong and I believe another one of the defendants in the criminal proceedings, he was bound by that absolute duty of confidentiality. And the courts recognize that even though you may think that you are able to hold to make the separation, they say you could, and their case law on it. There's a very famous case. It's an accounting case, but it's very famous, Prince Balke versus KPMG. It said you may by accident, not or inadvertence, slip and reveal confidential information that was given to you by your former client, which will be prejudicial to his case. And when you are a lawyer, when you do the code of ethics and you look at the code of ethics, it sets out the duties that a lawyer has. A lawyer has a duty to his client. A lawyer has a duty to the court as one of its officers. He's an officer of the court. The lawyer has a duty to his fellow lawyers to uphold the profession. And the lawyer has a duty to the public to maintain the administration of justice and for it to be held in the highest esteem. So that his duty, not only the duty to the client, which is it is a duty that he cannot, duty that he has an absolutely, it's unqualified. So that when Mr. Armour, senior counsel, was appointed Attorney General to deal with the Miami matter, which was a civil matter that the state was bringing against Mr. Quaitang and I think Galbaran. I don't know if it's Galbaran or Ferguson, but two of them. The point is, he had previously acted for that same Brian Quaitang and defended him in Trinidad in criminal proceedings over which the same airport scandal, over which the same kinds of information would have been disclosed confidentially to him. So, what happened? Miami courts disqualified the law firm that had acted for the state and disqualified the Attorney General. Why? Because he did, first of all, in his affidavit, an affidavit is giving witness, like if you're in the witness box,
Yeah.
As if you sit in the witness box and they ask you those questions. And in his affidavit, as I understand it, that Mr. Ferguson, one of the parties who was not actually a defendant, but certainly could give evidence, he said that Mr. Armour was a senior counsel since 2003. He acted for Mr. Quaitang in that matter from 2005 to 2008 or 2004 to 2008. So there's no way he did not know that he was a senior counsel. He's a senior counsel, is a very serious thing. You know how many people want to be senior counsel and can't be? That's the height of your achievement as a lawyer, as an advocate. So one, that he in 2003 was a junior counsel. How could you say that when you know you had to know that was not true? And secondly, that you would just resign to the place of a note taker. No senior counsel is a note taker. What a senior counsel is, he has his set of lawyers, 3 or 4 of them, who take in notes, who doing all what they call the heavy lifting, who do all the research and bringing it to him, for him to look at it and determine, because he's going to be the advocate. So, and they brought evidence that in the magistrate's court, he cross-examined someone, like a witness, for Mr. Quaitang. So it is such a mess. It is such a mess. So that affidavit is really what has put Mr. Armour in a very light, because it's one thing, it's gone Miami, and you said things that you had to know they were not true.
So Karen, should he then now resign as the Attorney General of Trinidad and Tobago?
Well, there's always meeting. I say first, the Law Association would have had their meeting today. And I think a number of the members of the committee may be in a similar position in looking at the matter, because as you may know, Reginald Armour was a former president of the Law Association of Trinidad and Tobago, not just very recently, actually. So I think the Law Association, he's a member of a body of persons, like how accountants belong and doctors. So I would want to hear what the Law Association view on the matter is. And I want to hear how they see it, because they don't have disciplinary power. They're just saying what they think on the matter as a...
If you had to give an opinion on the matter, what would your opinion as far as him, having to resign or step down?
As you know, it would be a very sad thing that if he had to. But it'd be a very sad thing, because I think he is very competent and unfortunate. And also too, he came into that situation. Let me just say before I answer you, because I'm thinking it out too. He also found himself in that situation. Not that he came and put himself, yes, I want to represent the state. Give me the brief. I want to do the brief. It wasn't a situation like that. He became the representative of the state by virtue of law under the State Liability and Proceedings Act, and by virtue of the Constitution, in particular Section 79(2), that says that any matter brought for or against the state in civil proceedings shall be brought in the name of the Attorney General. So what I am saying there is that I look at that as somewhat mitigating from the point of view that it is by virtue of the office he held, which was not very long ago. I don't think he anticipated that he would have been the Attorney General 6 months ago.
He could have recused himself, though. Couldn't he have recused himself? He could have
Well,
recused himself.
then you see the thing about recusing himself. I don't know if I could say recuse himself, but what he should have done immediately brought that to the attention of the Prime Minister and say, Prime Minister, this is a difficult situation here. Because you had already had discussion with the law firm
Right, right.
before he recused himself. And so even before he attempted to recuse himself, some of the damage would have been done. And remember, the basis of the prohibition against him acting is because the duty of confidentiality is unqualified, absolute, and it transcends the termination of retainer. It follows you all through to the end of time. So all I am saying is that I want to hear what the Law Association has to say. I want to see if there's some way that it can be remedied, but it certainly looks very bad on his part, because on his part, the part that looks really very difficult for me to try to defend is for him to have gone on affidavit and say that he was a junior counsel in 2003 when he knew that could not be true. And if he didn't know that was not true, then he had to suffer from dementia or something, and he didn't know that. So he's either incompetent or was not speaking the truth. And then to say he was just taking notes, I mean, that is so not true. And that they had to bring this thing to show that he was you don't allow someone to cross-examine unless you have the skill sets for that. So it is that affidavit where he said things that he had to have known could not have been true that I think is the difficulty he finds himself in. And he ended up
But Karen,
step
also
back.
right. But Karen, also right. So this is where I look at it, right? I'm not an attorney, but I look at it and say, if you recuse yourself after the fact, you know that you did something wrong. If
All
you
right,
recuse,
but in his case, he didn't have to. What makes his own a little more troubling is a senior counsel and in the post of attorney general, and in a case that has been before our courts for eons, the big corruption case, the Piarco scandal, and the names of Brian Quaitang, Ish Galbaran. I don't think they could go America, because if they go America, they will get the standing chance of being locked up, because everybody else who was in the cases serve their time and are out, and apparently they were prepared to come here and give evidence. So I don't feel that any three of them have made it to any American jurisdiction, because they stand the risk of being in prison. So it's a very serious matter. And my issue with it is that he failed in his duty as Attorney General, not only to his profession, not only to the thing, but to the public, because an Attorney General under our Constitution, as you well know, there are only two offices that must have to form a government, and that is in our Constitution. You must have a Prime Minister and you must have an Attorney General. Why? Because the Attorney General is the one, if you want, the Attorney General's department is when for most policies, whether it is property tax, whether it is revenue authority, whether it is gambling legislation, whatever it is, whether it's procurement legislation, it is the cabinet note. At the end of the cabinet note and finally the cabinet minute, the instructions are given to the Attorney General for the Attorney General's department, which is the drafting department, in which he got himself, Faisal Rawi got himself in a lot of hot water, to give instructions for the preparation of the bill to be taken to Parliament. So if you want laws to be passed, and Parliament is the ultimate court, and laws to become laws, the Attorney General plays a critical role in that. So his appointment is absolutely, you could appoint John Kwaku as Minister of, I don't know, anything you want to think of. But when it comes to AG, the Constitution says that you must have an Attorney General. And on that point, because of his role, when you go through history of the role of the Attorney General, because he's one minister that has a dual function. He has a duty to the government to advise it, but he also has a duty to the public to look after their interests. And it is that duality and that tension between the two roles that in United Kingdom, the Attorney General is not a member of cabinet. because they do not want them to have information which inadvertently, accidentally, they may use, which will not be in the interest of the country, but maybe the interest of a politician. Not that I'm saying that is the case. So it's a serious matter. So you ask me,
So do you think?
how would I
Do you
end?
think
I mean, he really is my friend, and I really
so
think
do you
really.
think you should resign or the private? I still asking you the question.
Yeah, I know you're
Based
asking that.
But answer before we get there.
Right?
Hello? You guys
wait,
hearing me?
go ahead, Karen. 1 minute, Gary. Go ahead, Karen.
Yes, I keep hedging. I keep hedging.
Yeah, you're hedging a
So,
lot. I
yes,
see, and
yes,
you're
I
not a
keep
hedger.
hedging. I
You're
keep
not a
hedging.
person hedging.
Yeah, because I like, because I told you
Go,
things
go
that
based
I'm
on the law, though.
debating.
Go based
So
on
I
what
think he
happened.
maybe should do the right thing and resign and not be asked to resign. I'm sorry that it had to end that way. But do you know something? No, this is
Yeah.
me, the cynic in me. This is cynic in me. You know, justice delayed is justice denied. So
Correct.
after millions of dollars have been spent by this government, whichever government, to a law firm, sequel thing, who have been disqualified. They weren't recused, you know. The judge disqualified the AG. The judge disqualified the law firm. And now what are we doing in Trinidad? We say we don't have money, but guess what? They're going to appeal that decision of the Miami judge. So you know how long they're going to take? Another 10 years. Guess what? Already, two of the defendants, one, Mr. Martin, was murdered allegedly by his spouse, and another defendant has died. So they're spending money got done, and justice denied is justice delayed is justice denied. So we may never ever see the end of that airport matter. If we go ahead to appeal to the High Court, Court of Appeal, Privy Council, we come back around, and it goes on and on and on, and money spending and nobody in jail.
Basically, Karen, Gary, I'm gonna get to you. But Karen, I just wanted to stay right. I'm not an attorney, but when I look at all the information and all the facts, I think he should do the honorable thing and resign. I agree with you. I agree with you that, what happened here for senior counsel, he can't get the best of this. He just can't get out of this. There's no way to wiggle out of this, and I don't think he should have put the prime minister in a position for the prime minister to have to tell him that he have to go. You know what I mean?